Welcome to another episode of The Dissection. It has recently been revealed that Philip Truter, the first man who was sentenced for his role in the looting of VBS Mutual Bank, is out on parole. He was the VBS Bank Chief Financial Officer when 2 billion rand was looted from municipalities and from poor villages in the Limpopo province. So during this particular scandal, Philip Truter received over 5 million rands in kickbacks. That's his share of the proceeds. But the whole scam couldn't have happened without him. As part of the scheme, Truter would create fictitious invoices, which were then credited to the accounts of his co-conspirators, and then he would then authorize those for the release out of VBS accounts into bank accounts which were held in other banks, right? The money flowing out of VBS was real money that had been deposited by the depositors, municipalities, grandmothers, villagers, you name it. Truter, when he was arrested with the VBS chairperson, Chifiwa Matodzi, with the CEO, Andile Ramavunga, the treasurer, Poppy Mukodobwane, as well as non-executive board members Ernest Nesane, Paul Magula? Yes, Paul Magula, and then the former CFO of the SAPS, Pala Avshoni Ramikosi, and the former KPMG engagement partner, Sipho Malaba. As you can see, there are a lot of people who were actually involved in the VBS scandal, who were arrested, who were charged, who were critical to this. But Philip Truter was the CFO, the Chief Financial Officer. Without him, none of this would have happened. So how is he out? He entered into a plea agreement and turned state witness. The agreement saw him pleading guilty to some of the charges which he faced, which included corruption, fraud, racketeering, and money laundering. As a result of turning state witness, entering into a plea agreement, cooperating, he was then sentenced in 2020 to 10 years imprisonment, with 3 years suspended for 5 years. So effectively, it was a 7-year sentence, right? And he was released on parole in April after serving 3 years and 6 months of this 7-year sentence. And this has now been confirmed by the Department of Correctional Services. He's serving the remainder of his sentence under community corrections until the 6th of October 2025. But basically, he's free. He's free. Now, he's been out since the 12th of April. But this was not reported at the time. It's only now being reported in July. Why was this hidden information? Why was the public not informed that one of the key orchestrators of one of the biggest corruption scandals in the history of South Africa is out on parole after 3.5 years, right? At the time of his sentencing, his wife Cornelia had told the court that her husband needed special care in respect to his health, and that his body and state of mind had physically deteriorated in the month leading to his plea. She claimed that he had premonitions and spiritual revelations which led to an intervention from a pastor. This is why perhaps he said that he was entering into the plea, and that at some point he was checked into the Vista Psychiatric Clinic in Centurion in Tshwane, right? At the time, she claimed that the scandal had taken a toll on their family and had led to financial ruin following his sequestration in 2018. She said that the whole family, including 3 minor children, were surviving on an income of 12,000 rands. And this may have had a bearing on how long the sentence was, the sentence that he was effectively given. Now, a lot of people are uncomfortable with the fact that somebody who committed this kind of a crime is already out and is already, back in civil society, enjoying time with his children, enjoying time with his family and wife, and all of the benefits that come with that, just after 3.5 years. After benefiting over 5 million and orchestrating the theft of billions of rands, you're out. And it brings to mind another example, Oscar Pistorius. Pistorius, right? Oscar Pistorius. Right, I said it correctly. Now, if you remember, Oscar murdered River Steenkamp in 2013. He appeared in court in March of 2014 in the Gauteng division of the High Court, right? And he appeared on 4 counts, murder, 3 counts of contravening the Firearms Control Act. In 2014, he was found guilty of culpable homicide and dangerous use of firearms. He was then sentenced later on in 2014 on culpable homicide. The sentence was 5 years imprisonment. And then on the Dangerous Firearms Act, or rather the contravention of the Firearms Control Act, he was sentenced for 3 years, which was wholly suspended for 5 years on condition that within the period of suspension, he was not found guilty of a crime where there is negligence involving the use of a firearm. The sentence in count 1 and the sentence in count 3 were supposed to run concurrently. This was the first sentence. This was appealed. It was taken to the Supreme Court of Appeal, and the appeal was successful. It was upheld. Oscar Pistorius was then found guilty of murder and sentenced to 15 years in 2016, right? He was then released in January of 2024, 11 years after committing the murder. 7.5 years of his sentence. Now, the questions that I really want to explore in this video and ask you, are sentences too short? Are they effective deterrents? Are the victims getting justice with these sentences? Is society getting justice? Are criminals actually looking at this thinking, well, if I can steal 2 billion, confess, I'll get out in 3.5 years. Or if I murder someone, I can get out in 7.5 years. Or even, is this whole system in need of a review? The sentencing system? Is the parole system in need of a review? Should heinous crimes be denied the right to parole? What do you think? Let's start exploring those questions in your head. But as you are listening, you may be wondering, how does sentencing work in South Africa? And this is what I'm going to cover now, right? A sentence is any measure applied by a court to the person convicted of a crime and which finalizes the case. Sentencing is the imposition of a sentence by the court on a particular offender. The court has wide-ranging powers to impose sentences. In deciding how to exercise this power in a specific case, the court exercises a discretion, which involves making a choice from various possibilities in the case of sentencing. These possibilities consist of the various types of sentences and normally also the measure of the type of sentence to be decided upon. The discretion may not be exercised arbitrarily. A court is expected to act within the limits prescribed by the legislature and in accordance with the guidelines laid down by higher courts. The basic requirement set by the Supreme Court of Appeal is that the discretion must be exercised reasonably and justifiably. The main advantage of wide discretion is that the courts can adapt their sentences to provide for the slightest differences between cases. The disadvantage is that should the same case be heard by 2 different judicial officers, there may be a very vast difference in the sentences that are imposed. This problem creates conflict with Section 9 of the Constitution, which emphatically stresses the equality of all people before the law. Inconsistency is generally viewed as unjust, and therefore inconsistent sentences are not consonant with justice and fairness. The general principles of sentencing were summarized in the Rabi case of 1975, and they are as follows. Number 1, punishment should fit the criminal as well as the crime. Number 2, punishment should be fair to society and be blended with the measure of mercy according to the circumstances. Number 3, all sentences should take into account the main principles of punishment, namely retribution. Number 2, deterrence. Number 3, prevention. And number 4, rehabilitation. Of these purposes, deterrence has for a long time been considered the most important purpose of punishment. As you're listening to this, do you think that these purposes are being met? Deterrence, retribution, prevention, when the sentences are so short, Oscars out, Truter's out. Are these sentences being met? Right? Now, the process of sentencing should ensure that every sentence should fit the criminal. Right? And this is known as personalization or individualization of punishment. The process is considered to be the main reason for leaving sentences with wide discretion. So that idea that the sentence should fit the criminal as well as the crime and be fair to society leads to this personalization or individualization of punishment. Do you think that it leads to fair outcomes? Let me continue. The discretion to impose a suitable sentence lies with the sentencing officer. However, the sentencing officer cannot do so without sufficient factual information on which to base this decision. Tradition seems to require the state and the accused to supply this information. Section 274.1 of the Criminal Procedure Act places the court in the center of this process and empowers the court before passing the sentence to allow evidence that will assist the court in determining a proper sentence. The term evidence here is not used in the strict understanding of evidence in the law of evidence. Things that can be considered, such as previous convictions. What normally would happen is that after a conviction, the state will indicate whether the accused has previous criminal convictions. The Criminal Procedure Act deals with this procedure in sections 271 to 273. If there are previous convictions, they are usually proved by simply handing in the accused's fingerprint record, which according to section 272 is prima facie proof of previous convictions. After the previous convictions have been dealt with, the accused is given an opportunity to supply evidence and mitigation of the sentence. Mitigating factors are frequently described by the accused or the legal representative simply by addressing them to the court. It has occasionally been heard that the address on a sentence should not include facts. Facts should have been provided by the evidence under oath. However, this approach is not consistently followed. Right? After all the evidence on behalf of the accused has been led, the state will normally also be allowed the opportunity to lead evidence and to address the court on sentence. Criminal proceedings are frequently postponed after conviction before a sentence is passed. This can happen because the state needs more time to obtain a list of the accused's previous convictions or because a pre-sentence report may have been requested. Section 275 provides any judicial officer of the same court. Section 275 provides that any judicial official of the same court may, if the magistrate or judge who convicted the accused is not available, consider the sentence after consideration of the evidence. Now, this is why Truter's wife mentioned all of those things. There were mitigating factors, that we're all living on 12,000 rands a month, etc., etc. This guy has gone through psychological trauma, all of that. And it looks as if it had a bearing on affecting his sentence. Then the question then becomes, should mitigating factors be taken into such consideration when these particular crimes that are being discussed are so grave, right? The court must take mitigating and aggravating factors into consideration. A large number of factors have already been accepted by South African courts, including factors such as premeditation of the crime, abuse of trust, the presence of remorse, whether the offender is married or employed, whether the offender is young, right? Previous convictions can be aggravating as opposed to mitigating. A person who has been previously convicted time and again of similar offenses will progressively be punished more severely. This is because the offender, by continuing to commit the offenses, displays a disregard for the law, and because it is believed that the heavier a penalty is, the more likely it is to deter the offender from committing more crimes. And that's the idea. Now, that's sentencing. Let's discuss parole, because I think in the Philip Truter case, there's this question about, was the sentence even appropriate? But you may also be wondering, okay, I understand sentencing now. How does parole work? Parole is an integral part of a sentence because it is a continuation of a sentence outside of the correctional facility. In other words, an individual who is on parole is still serving his or her sentence. Parole has various motivations, which include the following. Number one, being an alternative to imprisonment. Number two, rewarding offenders for complying with their sentence plan and participation in rehabilitation programs. Number three, combating recidivism by ensuring the gradual reintegration of offenders. Recidivism is repeat offenses. The Department of Correctional Services is equipped to do this, and it employs social workers and other experts to assess if the offender serving a prison term has been rehabilitated and, therefore, where applicable, should they be released from prison. The issue of whether or not the offender has been rehabilitated is central to determining if he should be pardoned. It was held in the case of Motseme versus Minister of Correctional Services and others that when the applicant, a fully rehabilitated offender, was not released on parole on several occasions, although the court had ordered that he qualified for parole, the court then said, although no offender has a right to be paroled, parole is an integral part of the penal system, and that where an offender therefore has demonstrated by his conduct that he has been rehabilitated and is not a danger to society, there is no reason why he should not benefit from the system. In State versus Smith, where the accused was convicted of multiple murders, it was held that it would be inappropriate for a court to impose lengthy prison terms in an attempt to eliminate any possibility of parole. What the court said, in an attempt to eliminate any possibility of parole, the granting of parole falls within the powers of the executive authority, and the court ought not to attempt to circumvent the exercise of this power. Right? So what the court was saying was, even if this crime is so bad, you should not, in sentencing, try to create pathways which block access to parole. Although the release on parole is not a right, the offender has a legitimate expectation that he will be considered for parole and will be placed on parole should he fulfill all of the requirements, for example, that he has served the non-parole period and has been rehabilitated. In cases where the offender meets all of the requirements for placement on parole and is not placed on parole, courts may intervene and order that he be placed on parole, as was the case in Motseme versus Minister of Correctional Services and others. Parole may serve the purpose of reducing prison population and dealing with the issue of overcrowding as well. So who grants parole? Under Section 75.1 of the Correctional Services Act, the Correctional Supervision and Parole Board, the CSPB, is empowered, after considering the report on a prisoner submitted to it by the Case Management Committee, to place on parole any prison serving a determinate sentence, determinate just means exact, exceeding 12 months, in respect of dangerous criminals and prisoners serving life sentences. The Correctional Supervision and Parole Board is empowered to make a recommendation to the court for their placement on parole. So I'm now thinking that perhaps one of the things that can be done is that the report on the prisoner, right, which is determined by the Case Management Committee, should be made public. I think that's something that can work, right? Section 73.6A of the Correctional Services Act provides that a prisoner serving a determinate sentence may not be placed on parole until such a prisoner has served either the stipulated non-parole period, or if no non-parole period was stipulated, half of the sentence. But parole must be considered whenever a prisoner has served 25 years of a sentence or cumulative sentences. So effectively, if you think about Truter, he served 3.5 years of his 7 years. So at that point, he was eligible to be considered for parole. Same applies to Oscar Pistorius. He served 7.5 years, right? They also added some of the time that he had served for the culpable homicide, and even the time that he was on parole for the culpable homicide as part of his 7-year sentence. So he was back, as you saw, quite early, and this is why. Section 73.6a raises 3 important points. Number 1, any prisoner serving a determinate sentence, apart from an offender sentenced to life imprisonment, may be placed on parole before or after serving half the sentence. The word may, as opposed to shall, gives the relevant parole authorities the discretion to place a prisoner serving a determinate sentence on parole where he has served more than half of the imposed sentence. Number 2, a prisoner who was sentenced to a non-parole period can be placed on parole only after he has served that period. In this case, the decision as to when an offender should be eligible for placement on parole is made by the court and not by the Department of Correctional Services. However, when the non-parole period expires, the Department of Correctional Services has full discretion to decide whether or not and when to release an offender on parole. The maximum number of years, number 3, that a prisoner can serve before he must be considered for parole is 25 years. This means that even if the court imposed a non-parole period of longer than 25 years, the Department of Correctional Services is obliged to consider the prisoner for parole after he has served 25 years. All right? Another relevant provision you need to be aware of. Under Section 73.6v, this is what it says. Under Section 73.6v, an offender sentenced in terms of the Criminal Law Amendment Act, which provides for minimum sentences for stipulated sentences, may not be placed on parole until he or she has served at least 4/5 of the term of imprisonment imposed, or 25 years, whichever is shorter. But the court, when imposing imprisonment, may consider that the prisoner be considered for placement on parole after he or she has served 2/3 of that term. So this is how sentencing works. This is how parole works. One of the questions I want to ask you is, should crimes like corruption, which happened in VBS, be considered in the same way that treason and murder are considered? That regardless of whether you confess or not, whether you take a plea deal, there has to be a minimum sentence, and that minimum sentence has to be very high, because treason and murder have the highest minimum sentences. However, the minimum sentence in and of itself for murder leads me to ask you a second question. Should murder have a harsher minimum sentence? Should they be minimum sentences of 25 years rather than 15 years for murder? And should crimes such as this kind of grand corruption be in that particular category? Personally, I think that when people who look at these things see that people are getting away with corruption, with murder, in terms of that they're caught, but they're coming out after 7.5 years, after 3 years, it doesn't create a deterrent. I don't think that there's an effective deterrent from these particular types of sentences. I think it just feels as if these people are gaming the system. 2 billion stolen, you're out in 3.5 years. That feels too short. You shoot your girlfriend through a bathroom door, 7.5 years later, you're out, back in society. I don't know, but it doesn't feel like these sentences are an effective deterrent. It really doesn't. And I also don't think that there is justice for victims when they know that 3.5 years later, let's say you deposited 100,000 in VBS and it took you 10 years to get that money in savings. And then the person who stole that money comes out after 3.5 years. How is that fair? How's that fair? I don't know though. I don't think that it does create a deterrent. I don't think it meets the deterrence and also the retribution elements of punishment, which are part of why we imprison people. What do you guys think though? I'm interested in us having the conversation. Philip Truter's out. Is out and about. Obviously, he played the game properly because the legal system also tries to encourage people, taking these plea deals, turning on against people, turning into state witnesses, it would be counterintuitive for the state not to do these things because they're trying to convict the maximum number of people that they can convict. So if you don't have these kind of plea deals available in the system, you may never be able to get every perpetrator because no one will be wanting to go to prison for a long time. But is justice being served? What do you think? Let's have a conversation. If you haven't subscribed to the channel, please consider subscribing. This is where we have interesting conversations about developments that are happening in SADC, in Africa, and in the world. Till the next one.